Okay, good morning. So since we have only 20 minutes, maybe we just take it from there, have a start. I maybe give you a short introduction who you're talking to. We are, as NER, we are a European law firm which is mainly based out of Germany, and we are very heavily invested in advising businesses on their tech issues, and in particular, tech companies coming newly up. Me personally, I'm based out of the Berlin office, which, as I'm sure you know, is become, by German standards, a very vibrant environment for tech businesses these days. And also, we are really excited to have the opportunity to be at this conference because the exchange between Berlin and Israel, Tel Aviv in particular, has become very strong and interesting, and more and more tech businesses and investors from Tel Aviv are coming into Berlin these days, creating a very interesting atmosphere, environment, bringing along their food, their culture, but also very interesting tech opportunities and ideas. And so for us, it was quite natural joining into this conference to taking part in that because we consider ourselves a key legal advisor in the tech space, and in particular in Berlin. We're looking at that both from the company investor side and also from the tech business side, because we feel it's quite fruitful one for the other, looking into both big companies driving their tech transformation, and on the other hand, going into the smaller emerging company space to help build up new ideas from the legal side. And now this session is basically about you and your questions. So I'd just like to give a couple of short remarks on what we feel is particularly important when you are a company that's in the European space, active in the European space, from a legal perspective. And I can say I'm the co-head of the digital business section for NER. And part of what I'm doing is really advising startup businesses on basically their whole array of operational issues. And maybe for a start, before we enter into a discussion into your question, I'd like to give you some overview on topics that I often encounter in advising such tech businesses. And this is more from a European angle than from a purely German angle. What we see as a key requirement when you're setting up shop, and we look at that from an investor's perspective and also from a company building perspective, is that a startup, a company needs to protect their core technology, and that is usually done by IP rights. So, and there's in Europe a couple of different IP rights here that we encourage you to look into, and some of that is trademarks, patents, domains. So those are registered IP, which you can look into, which are very important. And obviously on trademarks, there's a community trademark, so you can have a common registration across the European market. In patents, we are not quite there. We are working on it. But there's also the question, is it really a IP tech-driven business in the sense that it qualifies for patent protection, but there's a European unitary patent coming up. And also, of course, if you look across Europe, it's also very important to have domain protection around it. Core IP is usually around software. So what we oftentimes see is how important from an investment side it is to really acquire ownership, exclusivity there, and also Know-how protection is a big issue. I'd like to point you at a fairly new European directive, the Know-how Directive, which unifies the application across Europe, and that requires that you protect your IP, your know-how, by effective measures, so you qualify for. This is one of the big points that we always discuss with our clients, how to properly protect. Another issue that is key for setting up a business, obviously, is your customer contracts, usually terms and conditions, and those are, if you're looking at Europe, very different if you are in a B2B space or in a B2C space, because in B2B, you're basically free to apply the law that you want, and in B2C, you can also do that, but there's still a lot of consumer protection legislation which you need to observe. So that is usually, it means usually, unfortunately, it's difficult to have a common set of terms and conditions all across Europe, but you will still need to look into the details in the countries that are important to you. A third topic which I'd like to highlight is regulation, and there's a couple of different things you need to look at. There's partly Europe-wide regulation, regulations and directives, and there's coming up more and more regulation at a European level. Also, a very important task of the European Commission has been to the Digital Single Market Initiative to create standards across Europe for tech regulation. But this also includes competition law, which is at a Europe-wide level. Then something that helps you in order to be able to just focus on one common set of national laws is the so-called country of origin principle under the e-commerce directive, which means if you create an establishment in a European country, you can rely on in certain aspects, important aspects, on the national law in that country. But then also there's obviously some national laws that you still need to observe when you are looking into a country. Okay, so this is a broader overview. So let's look into one topic which has become tremendously important and discussed, which is the GDPR, which has been in place for more than 2 years now, but still we see efforts for companies to come to grips with it. And if you're looking to that from an Israeli perspective, it's very important to note that whenever you actually process European data, European personal data, it will apply to you, even where you don't have an establishment within the EU, as long as you process European personal data, you will need to observe it. What does it mean being bound by the GDPR? Essentially, data processing is heavily regulated. You need to have a legitimation to do it in the first place, and that can be a statutory permission. So the law says you can do it, especially in the context of contract fulfillment. And the other opportunity is actually obtaining consent from your customers. So that needs to be informed, unambiguous, and so you need to finally draw up a consent language for that. And finally, which I think is very important if you're looking at that from a Israeli perspective, cross-border data flows, meaning data out of the European Union to a third country, including Israel, is under particular regulation, and there's a good news for Israel because the European Commission considers the data protection legislation in Israel as sufficient, and it's said to be adequate. So it can be moved into and out of Israel from or to Europe without particular restrictions. One thing, though, to note is once personal data go out of Israel to a third country, in particular to the US, there are then requirements, and that is where one of the most important decisions recently of the European Court of Justice comes into play. There's been a contract between the EU and the US that said, well, data can be transferred to the US subject to specific requirements, which was the EU-US Privacy Shield. And recently the court held that this agreement is void because the protection isn't sufficient under European standards, and now we have quite an uncertain situation as to how we can still legitimize data transfers to the US, looking into encryption measures and others. So this is a big challenge. So now, so much for a brief overview. What we'd really like to do is discuss with you your questions you might have. So I'd like to open up the stage for you to jump in and raise your questions and discuss. Anything special to do or know in order to offer our services in Germany? Well, from a UK perspective right now, of course, a lot depends on how actually the Brexit and the negotiations will play out. Obviously, well, you're probably in a good situation in the sense that you are hopefully, or I assume largely in alignment with what European law says. But maybe to what I said before, it will, no matter what happens, still be important to monitor what European law says. And from a GDPR perspective, probably not that much will change, even no matter how Brexit will eventually be organized from a contractual perspective with the European Union, because so long as you process data of your European EU customers, you will still be bound. And then obviously one of the key topics is how to deal with that new decision. May I ask, how have you been dealing with US transfers these days? How has it impacted you? How have you dealt with the challenge that there is in relation to data transfers to the US, if you use Google services or something like that under the new decision of the ECJ saying that Privacy Shield is void and there's uncertainty as to the transfer of data to the US. Has that affected you at all? Okay, all right. So maybe saying a little bit more about Germany. Germany, in the context of consumer protection laws, is fairly strict. So if you build up your terms and conditions and you want to do business in Germany, it is fairly important to specifically look into that and tailor your terms and conditions to that, because there's consumer protection agencies, and we've seen time and time again that they even went after companies that are located outside of Germany. So we encourage and advise to look into that. That I think would be probably the main particularity about Germany if you're doing business there. Okay, so thank you for your participation. I think our 20 minutes are almost at the end. Thank you, and maybe we'll have a chance to discuss later. And so anyway, I wish you a great day and informative conference.